You're listening to the Max Planck Lawcast, which showcases the academic research currently being conducted across the Max Planck Law Network. I'm your host, Christopher Murphy, and together we'll be talking to some of the more than 400 researchers who are pushing the frontiers of legal knowledge in Germany and abroad. When it comes to new and exciting legal research, the Lawcast has you covered. Welcome back to the Max Planck Lawcast. Today we're diving into the complex topic of consent to sexual activity, exploring how it shapes our understanding of respect, personal boundaries, and human dignity. Now, consent is often seen or understood as something quite simple, a yes or a no, but it's far more nuanced. And we've seen in recent years across Europe that there's been a number of reforms in numerous countries to laws to better reflect and understand the complexity of consent. Although, as my guest today will tell us, these reforms or reforming sexual assault laws is a challenging task. So to discuss all this, I'm joined today by Tatjana Hörnle, Director at the Max Planck Institute for the Study of Crime, Security and Law. Her expertise in the modernization of sexual offence laws across Europe make her insights particularly invaluable when it comes to understanding these sensitive issues. So, Tatjana, a very warm welcome to the Lawcast.
Thanks, Chris, for having me here.
It's great that we could make it work today. And I know you had a very busy schedule, you were telling me on the way here. So that's great. I just kind of said there in the introduction that there's been movements of late, legislative changes. What, though, before we talk about those changes, was the status quo, I think, for decades prior when it came to the prevailing legal model of how we understand consent in sexual assault cases, and what triggered then this seemingly widespread change or a desire to update laws?
The traditional old model, which is actually going back centuries.
Oh, okay, not decades, centuries.
Centuries has been the so-called coercion model, which means it required an offender who applied violence, physical violence, or at least a threat of violence. And after that, after coercing the victim, sexual contact would ensue against the will of the other person. But the idea that this is a two-step procedure, you have to have coercion first, and then there would be an unwanted sexual contact. That's been widespread across Europe as the traditional model. In recent years, courts did find out that this leaves some gaps, where you would actually say, well, this was evidently a sexual offense. However, there was no coercion. Perhaps let me mention some examples.
Yeah, certainly.
One example would be surprise cases, where somebody is just very fast. You come from behind, so you can actually commit a sexual act without the victim seeing that, which means you don't have to threaten the victim because it's just a matter of being fast enough. Or the more frequent examples where when somebody clearly said no, absolutely no doubt about a no. However, for some reasons, the other person, the offender, could ignore that. One case which went before a German court was the man was the head of the local Hells Angel branch. He was visiting some friends and told the 18-year daughter, come to the bedroom, get undressed. She said, no, I don't want that. She repeated that, no. But because the social pressure was so strong, he did not need to apply physical violence. There was enough in the room.
Understood. And that was the issue, though, that previously the law was maybe trapped by its own understanding of sexual assault, that there was, as you say, no coercion, therefore no sexual assault, no offence.
No offence.
Okay.
So in that particular case, the court had to say no, this was not a sexual offence, even though she clearly said no. But he did not apply violence. He did not threaten explicitly, if you don't do that, I'm going to beat you up. He didn't need to. So there was no coercion.
Right. Okay. So there was a gap in the law, basically, that had grown over time.
Yeah.
Okay.
I mean, it probably always had been there, but the public and the courts themselves got more aware of that it's not a good idea to let cases like that just go unsanctioned.
Okay, so it's basically been the courts, the politicians, and the public in general realising, okay, we need to make changes here, so we need to update our laws on sexual assault.
Exactly.
Okay. If that was the coercion-based approach, which was most widely used for centuries, what then is the new approach that politicians and courts now are applying, and that a lot of these new laws, which we're going to be discussing later on, have also sought to apply?
So the new idea is to get away from that two-step requirement, which means you can have a sexual offense without having coercion. If you do have coercion, this is an aggravating factor. So if you have an offender who threatens and beats up the victim to obtain sexual services, this would be higher punishment. But it's not the minimum threshold. So the idea is to focus on the sexual act and to ask, was this covered by consent?
Okay, so that then is the more modern approach, then is the consent-based approach, where it's not saying was there coercion, was there violence or not. It's taking a whole range of other factors in each case into account then. Because that was one, when you were mentioning the examples there, one I thought of as well was deception. I remember back in my legal studies, that was also a case where it didn't actually involve violence or a physical threat, but it was being pretending to be someone else and deceiving the victim into then sexual contact. Yeah.
Well, this is already a question of details. If you make that step away from coercion as a necessary requirement to lack of consent as the necessary requirement, there are still a lot of details which need attention. For example, what does consent mean and what are conditions to make consent valid? And deception is one example where there's a lot of discussion going on whether deception should be included or not.
Okay. Right. So this is what the discussion between coercion and consent, that's kind of at the meta level, and then we go down, which we'll do. We're going to talk about that now, I guess. What is consent? And so that is, I guess, my next question, because that was something I noticed in preparing for today's podcast. I read your paper, which is on, I believe, Germany, Sweden and Spain and the reforms there to their sexual offence laws. And what struck me as rather interesting was that each jurisdiction had a difficult time deciding what was then consent and pinning it down exactly. Why is this the case when it comes to legally defining consent, that there seems to be a challenge there?
Well, for most people, including lawyers, the idea that consent should be crucial first sounded quite simple. So you would write a law and would apply your intuition, what consent is, and write that into the law. But it turns out it's much more complicated than that. You have to make some basic decisions, what you actually mean. Probably the most fundamental question is consent something you communicate? Is it a matter of communication? Or is it something which happens in the person's mind? Would you say somebody is consenting when this person is in her mind, thinks, well, this is something I want, or let's do that? Or does it matter what this person communicates? It doesn't matter if she or he would say, well, let's do that? Or is it enough if this process of having a positive attitude is in one's brain? Or does one have to talk?
Okay. How is that termed then in the literature? There's given consent, and what's the other type of consent then called? Presumed consent or?
No, presumed consent is a different concept. So the question would be, I mean, it's probably most easy to explain if you imagine you're a judge or a police officer. What kind of question do you need to ask to the victim? The crucial difference is if you inquire, well, what did you say? What did you communicate with your gestures? How did you behave? So if you take the outside perspective. Or if you inquire, what did you think? What did you feel? Did you want that? These are different kinds of questions you have to ask.
Okay. And then obviously what you're also saying though here is with consent there's different questions, different models then. Different models about what kind of questions we ask in a court of law. And that also surprised me because I was as you say, for the lay person, one thinks, oh, consent is probably if I look in the dictionary, there's probably a fairly succinct definition of consent. But we're talking about completely, not the dictionary definition, every case coming before a court is different. And so there have been different models then developed about how to best then go ahead to try and tease out or understand was consent given. I found it complex, the models, but I was wondering if you would be able to briefly explain then what these various models of understanding consent are.
Mm-hmm. I mean, this is part of what I've written about the last 10, 15 years. And I would distinguish, but this is still not a standard legal terminology. But I think it's helpful for criminal policymakers to have some conceptions, how you actually call that. So I would distinguish the attitudinal model, which also used in the literature more generally, to say attitudinal means the person's inner attitude is the crucial point. The other model is the communicative model, which would mean it matters how you express your attitude towards having sex or not having sex, how you express that, how you communicate it. So this would be the two basic types. And then if you begin with that, there's another important distinction. If you go for the communicative way, if you think we should apply a communicative model, then there are two major options. Yes means yes, or more precisely, only yes means yes, or the other one would be no means no. Mm-hmm. So in the end, you have three models.
Okay, you have to break me down there. We have the
attitudinal and the communicative.
Yes.
And within the communicative
the
strand,
communicative has the second.
You have another distinction, yes
okay, whether you want
no.
to. Right, okay, understood. Okay, right. We've done a lovely job explaining that to me, because when I was reading the paper, I was really, my brain was cooking on 110 degrees. I was like, wow, I found it, as I say, I found it very dense, I guess, the material there. But thank you for doing such a good job there. That makes it much easier for me now to then ask. A follow-up question to that is that, okay, if a jurisdiction decides we're going to go with the coercion model and we're going to take the yes and only yes means yes.
We're going with the consent model.
Oh, gosh, look at me going here. We're going with the consent model. So we're going with the consent model. Thank you for picking that up. We're going with the consent model, which says, and we're choosing option A, which says yes and only yes, means that I'm willing to get involved in sexual activities. That then means, though, that this could be different to the jurisdiction that chooses the attitudinal model, that the outcome could maybe be not only different in a court of law, but also, I guess, all the processes that lead up to it, evidence gathering, discussions in court, questions, as you say, asked. So that means then that a sexual assault in one jurisdiction could be considered to be not a sexual assault in another?
Oh, that's a good question. If you have a only yes means yes model, the outcome would usually be the same than if you have an attitudinal model. Because if the person says yes, the likelihood that this actually also means the attitude, if you only look at what did the person feel and want, would be the same. Because usually if somebody says yes, the attitude would be the same. But obviously always there can be divergences between the two models. And I personally think the communicative model is the much more straightforward, fitting for legal issues, because obviously it's also impossible years or perhaps months later to reconstruct what went on in a victim's mind at that moment. It's much easier to ask, but what did you say? How did you behave? What did you do? These are easier questions than to ask, what exactly did you feel?
Okay.
In January 24. That's much harder to answer.
Okay, so in some ways the communicative model then is more broad than the attitudinal model. It could also take the attitudinal model somewhat into account.
They are not necessarily contradictory.
Okay.
If you ask me, where do you have a clear difference? It's between yes means yes and no means no in some cases. You will have different outcomes. It's clear to describe that the choice of either a yes model or a no model means that you will have in some cases different outcomes.
Okay. Well, don't go away. I'm going to be back now with Tatjana after this very short break, and we're going to be talking about some of the key challenges and takeaways when it comes to reforming sexual assault laws.
Allow us to introduce you to the wealth of information found on the Max Planck Law website. Discover a range of events, From researcher-led presentations and reading groups to workshops and conferences, many of which are open to the public. Keep up to date with our news, explore the tangible impacts of our research, and peruse Perspectives, our online publication offering insightful articles on current legal issues. And of course, for those looking to pursue a PhD or postdoctoral research, you will find everything you need to know about our many academic opportunities. Visit our website today, law.mpg.de.
Okay, well, welcome back to the Max Planck Lawcast. I'm joined today by Tatjana Hörnle, and we're discussing the legal concept of consent in light of recent reforms to sexual assault laws in Europe. So, Tatjana, before the break, we talked about, I guess, the various ways that the law can understand consent. We touched on how various countries are reforming their laws. And what I'd now like to ask, though, and I guess that would have been my question for your final answer there, is that we said that this is the communicative model. Mm-hmm. That's right, the communicative model with the yes and only yes means yes and no means no, could lead to different outcomes in a court of law. I was wondering and also if we take the attitudinal model into account, what would lead a country or a jurisdiction to choose one model over another? Is it a societal factor, political, historical? What would that be?
Well, that's a complex question. I don't think there's one clear answer to it. It really depends. Sometimes it can be just a matter of contingency. Who is writing the law? Who is doing the drafting job? It's not always very clearly discussed what certain words actually implied. But today now, after the reform process in Europe has been going on for a couple of years now, probably people are more reflective. So one of the points to be asked, for example, would be, what do we expect from victims? What do we expect that people actually say no if they don't want to, which would mean an obligation? Or are we asking from the offender, actually, in every case, or from the potential offender, to actually ask for the opinion of the other person? And this also means that the discussion has been influenced to how powerful are feminists in this discussion. That's something which you can see. I personally propose the no means no model, mm-hmm. which means that you have to say no. Perhaps I should also explain what's the difference between the two models. We haven't really talked about that.
Please do so. Yeah, the two models as in the yes.
Yes and no.
Yeah, please do. Absolutely.
What cases they lead to different outcomes. That's important for mm-hmm. the choice of the model. Mm-hmm. So one choice to be made, again, would be, do you really need to say no? And the difference comes up in cases which are not from the perspective of an observer. Imagine there's somebody looking at the events. And if this hypothetical observer would say, well, I don't know, this was a kind of ambivalent situation. What did both persons want? Well, it's clear for one who wants to have a sexual interaction, but what did the other person want? Was it a positive attitude or not? She did not communicate. If you take this case, the no means no model would say, well, the person would have to say no. Mm-hmm. If the person does not do it, the other person is not a criminal offender. The only yes means yes model would come to the completely opposite result and would say, well, if this is ambivalent, you don't know, you have to ask.
Okay.
And only if there's a positive, affirmative signal, a yes verbally or some kind of conduct, then you're allowed to proceed with sexual acts. So this model would mean the offender would be punished.
Okay, so that's, as you say, as the neutral observer, if you see this, then, and we're talking about different outcomes, there would be, in this kind of case, a different outcome.
Exactly.
Okay.
So this leads again back to the question of how would a legislator decide? That's one of the key questions. Do we require that people in sexual interactions which are ambivalent, or the situation is ambivalent before sexual interaction? Ambivalent interaction, people know each other, but they are not lovers. People know each other, and perhaps they might have an intimate relation, but perhaps not. It's just unclear. So do we require from the person who does not want it to say, well, no, I don't want this? Do we have a communicative obligation? If you say yes, then you go for a no means no model. If you, however, say, well, no, the other person needs to ask, the burden is on the other person to get a yes, then you will opt for a only yes means yes model. And very often, in my experience, it depends on how vulnerable you perceive people to be. So if you think the law should protect vulnerable persons particularly, or should not demand too much from human beings, you would say, well, we need a only yes means yes model. If, however, you say, well, as citizen, you should be able to say no if something happens you do not want, then you go for a only no means no model.
And that's then something that is discussed in Parliament or in committees, or how do they go about reaching that decision?
Ideally, it should be thought through what the consequences are, and you should discuss this issue clearly and openly and say, if we adopt a no means no model, then this means human beings have an obligation in potentially sexual situation to express their attitude.
Okay. And we're talking, because up and down we talked a lot about verbally expressing a yes or no, but obviously, as you just said there you can also express this by other ways.
Yes, of course. Okay. In the criminal policy discussion, there has been fun made about the only yes means yes model. Some people would say, well, what does that mean? Do you have to have a written contract and write down what you agree to and whatnot? No. It means expressive conduct in general. Okay. This could consist in undressing yourself or smiling enthusiastically and that kind of stuff.
Okay, right. I mean, you've looked at a number of jurisdictions. Is there an interesting divide, north, south, Europe, east, west, or is it kind of scattergun approach the model that's chosen?
So far, I could not describe a clear pattern because the earliest reform movement have not really clearly been based on thinking structurally on the differences and a serious attempt to find the right wording. For example, in Sweden, the wording is not participating voluntarily. And it's kind of not very well phrased because you don't really know, is it a communicative model or is it an attitudinal model, because it's not written in the materials, because they didn't really think about that. Right. They had a vague idea, consent matters. But what consent means, that it can mean different things. The Swedish legislation obviously was not aware of that.
Okay. Was that because they were kind of pioneers in the... Okay, right.
In Central Europe, they were one of the first to actually do that.
Okay, I see. Okay. Then I guess my next question then I'd like to ask, and this has somewhat to do with what we've been talking about the whole time here, is the complexities and the fact that lawyers have a hard time defining consent, putting it down on paper. Or how important is it then that these laws are clear, defined, understandable, so that the common person can understand them? I mean, that's clearly what they're there for as well. And also a knock-on question would be, or how much should be left to judicial interpretation? What's the role of the judge and the court in these kind of matters? Should they be given a lot of leeway, or should they be kept on a tight rein?
Well, the answer to that question obviously depends on the legal culture. In Germany and in continental Europe, the idea is leave as less leeway to the courts. The written statutory text should define as precisely as somehow possible what is prohibited and what is legal. And I would defend that. It has to do that the law has to be understandable for citizens. It has to inform people. You need to have a chance to understand that simply by reading the text of the law, where the criminal law defines the boundaries. Okay, so that should be all-encompassing, but yes, as you say, it should define the clear boundaries of the offence. Yes, what also needs to be added in Germany, it's part of the constitution as well, because we have a constitutional requirement to define as precisely as possible.
Okay. I'm guessing there are certain jurisdictions, though, which don't have this. I'm thinking maybe the common law jurisdictions,
yes, exactly.
Us troublemakers.
Yeah. I mean, traditionally, it has been considered perfectly fine to leave crucial defining tasks to the judiciary. I mean, you also see in the common law countries, you see a movement towards more statutory law.
Absolutely.
And interestingly, some issues are better and more clearly defined in common law systems than in German law, for example. So it's not as clear-cut, that divide anymore.
Okay. Yeah, I would say I certainly noticed that as well when I was doing my law, that, I mean, a lot of it was statute law and more complex statutes as well. So then that would mean that in Germany, the desire would be that for the judiciary should need to ask as fewer questions as possible and should be fairly clear-cut when a case comes because the parameters of the law has described exactly what is or is not required.
Well, I was consciously saying as far as possible. I would say it's not feasible to actually write law in the area of sexual offenses in a way which leaves no question open. There will always be question how to interpret the statutory terms. But to define the general line, do we require a communicative approach or is it a mere attitudinal approach? That's feasible. That's something the legislator can do by thinking about it, finding the words, but there will always be difficult cases.
Okay, fair enough. I guess coming towards the end of our interview now, but I wanted to ask two more questions. And one of those has to do with the fact that, and I may be wrong here, but I had assumed that often, I mean, in cases where there's public outrage, we saw particularly in Spain and Germany, there was cases there which shocked the public, sexual assault cases and offences in Germany on a very large scale and in Spain very vicious, which clearly a justified public was saying, we're not happy with this. Was this the reason then for the changes in those two jurisdictions? And would you say that this kind of justifiable public outrage is a good way to influence law reform?
As a matter of legal history, you're absolutely right. In these two countries, it was the crucial event to convince the public and, even more important, to form political coalition. If you get a topic in the newspapers, in the media for a while and there obviously is a lot of public uproar, then this will have an impact. You saw that most clearly in Germany in parliament because the women across all parties, which was really an interesting experience, across all parties, the female parliamentarians actually drafted the new law. So there was a very strong movement, and this would never have happened unless they were pushed by public pressure. And the same happened in Spain. So the initial movement towards law reform has been very much promoted by outside pressure. Today, I mean, we see some examples of more quieter, better structured law reform where parliamentarians think about reforming the law simply because they see the movement. They see the other countries have done that. The coercion model is obviously outdated, so we have to do something. So now it's no longer necessary actually to apply public pressure to get reform going.
Okay, right. But at that time, it was actually quite essential for that reform.
Yep.
Okay.
Yeah.
Well, I mean, given, I guess, the complexities of consent that we have discussed today, I'd like to end on a final question, which would be, what would you say are the crucial lessons that countries who are looking to still reform their laws on consent could learn from, jurisdictions like Germany, Sweden, Spain?
Mm-hmm. Well, it needs to be a careful procedure on part of the lawmakers. So you should not say, okay, we want to get rid of an old coercion-based model, and we want to have a consent-based model. And then we take the first words which come to our mind to formulate the exact new prohibition. You need to go through that procedure and think, what does consent mean? Does it mean communication or inner mental state? If we go for communication, does it mean yes or no? And you need to pay attention to factors that might invalidate consent, like deception, for example. There are a lot of questions you need to ask yourself and find an answer. And after you find an answer to each question, then you sit down and actually write the text of the law.
Okay.
But don't do it the other way around.
Right, fair enough. Yeah, okay. Well, Tatjana, I'd like to thank you so much for coming on to the show today, for telling us all about consent and talking about going beyond yes and no, as the episode is titled. And thank you so much.
You're welcome. It was fun.
Thanks for listening to the Lawcast. If you'd like more information about Max Planck Law, or if you'd like to get involved, please visit us at law.mpg.de.
Max Planck Law. Excellence in legal research.